So welcome everybody to this webinar that has been organised by the Constitutional Law Matters Project, which is a project that has been organised by myself and Professor Mark Elliott. I'm Alison Young. I'm a Professor of Public Law here at the University of Cambridge, and it gives me great pleasure to introduce to you this evening Lord Carnwath, who is going to be lecturing us today on the Human Rights Act reform and looking at the issue of whether it is time for a new British Bill of Rights. Now, Lord Carnwath almost needs no introduction, but I'm going to give him one anyway, so I hope he doesn't mind. So Lord Carnwath studied law here at Cambridge at Trinity College after a very successful career at the bar, in which he also acted as the Attorney General to Prince Charles. He was elevated to the judiciary at first in the Chancery Division. And during his time in the Chancery Division, he also acted as chairman of the Law Commission. So he had not just a role in judging in the law, but also in thinking about modernising and developing the law through the Law Commission. He then was a member of the Court of Appeal, and during that time was also senior president of the tribunals. So he's also been involved in implementing tribunal reforms that came from the Legate Review. Most of you will know Lord Carnwath through his membership of the Supreme Court, particularly with regard to his decisions in lots of key cases, particularly in constitutional law. So Lord Carnwath was present in Miller 1 and Miller 2, and also in Privacy International. So he's had a huge impact on public law and also, more importantly, in environmental law and in planning law. And last but hopefully not least, he has recently been appointed as the York Distinguished Visiting Fellow of Law here at Cambridge. So hopefully now we've resolved all our technical difficulties, I can hand over to Lord Carnwath for what I know will be a very interesting and stimulating lecture.
As Alison has said, I'm going to focus on the recent review of the Human Rights Act by a panel under Peter Gross, which I'll call the review, but more specifically, the government's consultation paper, which followed it, which I shall call the consultation paper, or CP. But before I get on to them, I just want to look back a bit. I mean, I've been in the law for over 50 years, and I can't remember a time in that period when the convention hasn't been the subject of lively debate. Back in the 70s and 80s, we were mainly interested in the development of judicial review, and the courts weren't terribly interested in the Human Rights Convention. Indeed, even Lord Denning, writing in 1982, said of the Strasbourg Court, "Let us not be bound by the decisions of judges who do not know our way of life nor anything of the common law." Now, I think that was a missed opportunity. Lord Denning, of course, played a leading role in the development of the principles of administrative law and judicial review. And had the convention been part of our law then, I'm confident that British judges would have played an important part in the development of it, and it would have been there at the formative stage. But instead, the Strasbourg Court developed its jurisprudence without our assistance. And I think it would have made much less of a shock when we eventually joined the convention through the Human Rights Act in 2000, if there had been British involvement at an earlier stage. And I think the result has been a continuing suspicion of the convention and of the Strasbourg Court. But in those early days of my practice, the Strasbourg Court was in fact of little practical significance. We accepted its jurisdiction in 1966, but that went almost unnoticed. And it wasn't until the later 70s and the 80s that the Strasbourg case law developed to any real extent. And when it did, I think it did show that the much lauded human rights principles that this country has developed since Magna Carta had a lot of gaps. I have enjoyed very much reading a lecture given in 2012 by Lord Simon Brown, who was, of course, a member of the Supreme Court, but in his practice, he had been Treasury Junior, and he had done a lot of cases for the British government in Strasbourg before we joined the convention through the Human Rights Act. And I'm afraid his lecture is not that easy to find. I promised that I would mention, I said I would mention in this lecture, and I said I'd also mention where you find it. You find it in his memoirs called Playing Off the Roof and Other Stories, A Patchwork of Memories, which is a very worthwhile buy. It's a story of his life, but also with a lot of anecdotes. But he put in at the back his lecture on the development of human rights in this country. And he tells us of his experience as Treasury Junior doing cases for the government in Strasbourg. And as he modestly says of his record as advocate, quotes, "My overall record before the court was, I think, played 12, won 1, drew 1, lost 10. And he said most of the cases were about prisoners' rights or immigrants' rights or rights of mental health patients or other disadvantaged minorities. And the plain fact is that in those pre-HRA days, the convention and the Strasbourg rulings, striking down various of our antiquated laws embodying old-fashioned and illiberal attitudes, had an altogether healthy impact on the UK domestic life and practices. In those days, indeed, the government was in fact on occasion quite happy to lose its cases." I think that's quite, I mean, Simon Lord Browne is not by any means a sort of judicial activist, but it's a very useful reminder that we did have a lot of catching up to do. I mean, one example he gives is the case of silver in the United Kingdom, in which the applicants complained that the prison authorities were exercising unnecessary control over their mail, reading all the correspondence sent to them and their own letters out, even their letters to lawyers. And the court found a violation of both Article 6 and of Article 8. But this was in fact welcomed by the Home Office because it enabled them to face down the opposition of the prisoners' officers' unions, who were very resistant to liberalizing changes. I was in 1998, when the Human Rights Act was passed, I was chairman of the Law Commission, but I was also a judge of the Administrative Court. And in both capacities, I strongly welcomed the incorporation of the convention in some form. I found it unnatural and deeply frustrating that we were subject to a system of laws for the protection of basic rights under European law, to which we as judges in this country were unable to give direct effect. The convention, to my mind, also offered a logical structure within which to develop and apply the somewhat amorphous protections given by our own laws, with the support of a substantial body of authoritative jurisprudence from the Strasbourg Court. I also had the advantage in that period of sitting as an ad hoc judge of the Strasbourg Court in a Grand Chamber case from this country. And I was very, very impressed by the level of debate from judges coming from widely differing legal systems, but able to find common ground in the basic rights enshrined in the convention. So I welcome the 1998 Act as a simple and elegant way of consolidating those rights within our law, while respecting the key principle of parliamentary sovereignty. And since then, my own experience as a judge in the higher courts and as senior president of tribunals is that, with a few exceptions, mainly in the field of immigration, to which I will come, we've been able to establish a generally acceptable balance between the protected rights and the discretion given of government and indeed the role of parliament. And indeed, in a recent case, the Supreme Court have reaffirmed in emphatic terms the need for restraint when considering issues of proportionality in contexts such as social security. And I'll read what Lord Reid said in a unanimous judgment. The answer to such a question can only be determined in a parliamentary democracy through a political process which can take account of the values and views of all sections of society. Democratically elected institutions are in a far better position than the courts to reflect a collective sense of what is fair and affordable, or of where the balance of fairness lies. Now, since the 1998 Act, there's been a continuing political debate about the convention about its implementation by the Strasbourg Court and the UK courts. There have been also a number of initiatives at political levels to modify the approach of the Strasbourg Court. And it's fair to say that the United Kingdom has led the way in that process, notably in the Brighton Declaration of 2012, which proposed increased emphasis on the principle of subsidiarity and the doctrine of the margin of appreciation. This proposal was given effect by Protocol number 15 to the Convention, which came into force last August. And in the same vein, the Copenhagen Declaration of 2018 could affirm the central importance of dialogue, both judicial and political, between the states and the European Court for the effective operation of the Convention. Sorry, forgive my cold. Now, the practical effect of these various initiatives has not yet been fully worked out in legal or political terms. Now, at domestic level, there have been various calls for reform, either for replacing the Human Rights Act or other measures. And indeed, the 2015 Conservative Manifesto included a specific commitment to a new Bill of Rights, but that was overtaken by the political upheavals resulting from the European referendum. Now, that proposal for a new Bill of Rights was not repeated in the 2019 Conservative Manifesto. That referred simply to updating the Human Rights Act. And that led in December 2020 to the establishment of the expert panel under Sir Peter Gross, formerly Lord Justice Gross, by the then Lord Chancellor Robert Buckland. And that was based on the fixed premise that the UK would remain a party to the European Convention. There was no suggestion that their terms of reference involved looking at the possibility of replacing the Human Rights Act. They were asked to consider two main themes. First, the relationship between the domestic court and the European Court of Human Rights. And secondly, the impact of the Act on the relationship between the judiciary, the executive, and the legislature. Interestingly, the panel noted that although not within its terms of reference, it had received some submissions proposing a new Bill of Rights or outright repeal, but they commented that there was in fact an overwhelming body of support for retaining the Human Rights Act, and no evidence of any depth of support for either of the alternative proposals. Their report, submitted in October last year and published in December, is a thorough and painstaking review of the operation of the Act in the domestic courts, and brings together a wealth of valuable material and insights. It reads generally as an endorsement of the present arrangements, with very limited proposals for significant change. One important recommendation is for an effective program of what they call civic and constitutional education on human rights and individual responsibilities. They say, I quote, "We are in little doubt that there's much room for increasing understanding of the UK's constitution, and particularly of the Human Rights Act, the Convention, and the European Court, not least that they originate from international obligations that predate and are entirely distinct from the UK's former membership of the European Union." And as I'm sure a lot of you will have come across, there's quite wide misunderstanding about the balance and the difference between the European Court of Human Rights in Strasbourg and the European Court of Justice in Luxembourg. They also, I think, very significantly emphasize the importance of judicial dialogue. There's a very detailed account of the dialogue over recent years, and in particular of the respect shown by the Strasbourg Court for the judgments of the UK courts. A striking example was a case from Denmark relating to the issue of preventative detention under Article 5, in which the Grand Chamber referred to the analysis of the Strasbourg case law by the UK Supreme Court as part of their justification for reviewing and not following one of its earlier decisions. At a meeting that the Gross panel had with the European judges, they referred to the value of UK interventions in cases from other countries. That really ties in with a comment that Lady Hale makes in her memoirs, which again I can strongly recommend. But she says this: because the rights protected by the European Convention are now also protected by UK law, we can consider whether they have been breached in the same way as the Strasbourg Court would do. We are talking the same language. That is why the UK has lost far fewer cases in Strasbourg since the Act came into force than it did beforehand. And that passage was recently quoted with approval by Judge Spano, the president of the Strasbourg Court. It is clearly the view of the Strasbourg judges, and to my mind, a strong argument for retaining the language of the Convention in our own law, that it not only reduces the number of successful challenges in Strasbourg, but also enables us more effectively to influence the development of their jurisprudence. The Gross panel made two substantive proposals. One was for amendment of the Section 2 to give more priority to UK statutes and the common law, and the other was for the institution of exchanges with the Council of Europe and the Strasbourg Court to address problems created by the extended extraterritorial and temporal scope of the Human Rights Act, resulting from decisions of the Strasbourg and domestic courts. I entirely endorse the latter proposal. I think we do need to do something about the territorial scope of the Convention, following indeed decisions of our own courts. I'm less convinced by the suggestion that we should give more priority to common law. It seems to me in principle that if the Convention confers rights, then people are entitled to rely on them, and then the court is not required to look around for common law equivalents. I won't spend time on that, but I only say this, that one of the case which is referred to there was a case called Kennedy and the Charity Commission, in which concerned a journalist who was seeking information from the Charity Commission following a statutory inquiry conducted by them. And when it reached, that was sought basically under Article 10 of the Convention, but when the case eventually reached the Supreme Court some 6 years after the request had been made, the court said that they should have gone for a common law right, which the court said existed, even though none of the parties had supported it. You may gather from that I wasn't wholly convinced by my colleague's judgment, and I wrote a rather strong dissenting judgment, to which I'm happy to refer you if you want to know more. But anyway, I'm not going to dwell on that, because that is not in turns part of the government's proposals. The government would suggest that there should be an amendment, or indeed a replacement of Section 2 of the Human Rights Act. Now, you'll recall that Section 2 simply says that the court must have regard to decisions of the Strasbourg Court. The new bill proposed by the government goes much further. I'm sorry, I've jumped over the introduction to because what I didn't tell you was that how the new consultation paper came into being. I was trying to save time. As I say, the Gross panel reported in October 2021, but their report was not published at that time. There was, in September 21, a change of the Lord Chancellor. Dominic Raab became Lord Chancellor instead of Robert Buckland, and it looks as if he had a rather more radical agenda, because the paper, which was then the consultation paper, which then came out in December 21 and was published at the same time as the Gross report, isn't really a response to that paper. It's much more a set of new proposals and a new justification. And most significantly, it proposed that the Human Rights Act should be replaced by what was called a new Bill of Rights. This, it was said, would the new bill, it was said, would remain faithful to the basic principles of human rights in the Convention, but it would, quotes, reverse the mission creep that had meant human rights law being used for, quotes, more and more purposes, and often with little regard for the rights of wider society. It would act as a check on the expansion and inflation of rights without democratic oversight and consent, and will provide greater legal certainty. Then it was said, quotes, the rights as set out in Schedule 1 of the Human Rights Act will remain. We regard the Convention as offering a common sense list of rights. The key problems have arisen from the way in which those rights have been applied in practice at both the Strasbourg and domestic levels. These proposals will not therefore create any fundamental conflict with the Convention, nor necessitate our withdrawal. Now, so that's the basic idea, a new Bill of Rights in substantially the same language as the Convention, but apparently in the hope that it will lead to a different approach by the domestic judges. And to emphasize that point, the new Bill of Rights, it said, would make clear that the UK Supreme Court is, quotes, the ultimate judicial arbiter of our laws in the implementation of human rights. And this, it is said, is because the domestic courts are better placed than international courts to determine our laws, including relating to the training, caliber, experience, outlook, and legitimacy of our senior judiciary. Equally, the UK's own constitutional history and law can best be understood and given effect by the UK's own court. Well, you would understand that I'm not going to quarrel with that statement as such, but it's slightly ironic that most of the cases that are referred to in the paper are, in fact, decisions of the UK courts rather than of the Strasbourg Court. But in any event, the more controversially, the new bill would provide in terms by a suggested replacement of Section 2, not instead of saying that the courts must have regard to the Strasbourg case law, it would say, quote, the courts are not required to follow or apply any judgment or decision of the European Court of Human Rights, that the meaning of a right in the Bill of Rights is, quote, not necessarily the same as the meaning of a corresponding right in the European Convention on Human Rights, and that the courts, quotes, may have regard to relevant judgments from other countries and international courts outside the UK. So the idea is to sort of set us free from Strasbourg, although we're still, I think, we'd still be entitled to have regard to it. Now, I must say that with or without a new bill, I find it impossible to understand how a suggested replacement of Section 2 would advance the government's stated objectives. Section 2, as it stands, simply requires the court to take account of judgments of the Strasbourg Court, and the domestic courts have interpreted that in a practical way so that we will normally follow a clear and constant line of decisions, provided that its effect is not inconsistent with some fundamental, substantive, or procedural aspect of our law. Now, this approach seems to me entirely logical reflection of the status of the Strasbourg Court as the final arbiter of the meaning of the Convention, to which the Act gives effect, while recognizing both that not all its decisions have equal effect, equal weight, and also the margin of appreciation allowed to member states. And so long as we remain parties to the Convention and subject to the Strasbourg Court, as it's intended that we should, the same logic must surely apply. I mean, it's difficult really to see how it's meant to work. As I understand, the court's invited, in effect, to set aside the jurisprudence developed over the years since the Human Rights Act came into effect, and to start again. We're not required to give any particular weight to decisions of the Strasbourg Court or even of the UK courts, but we can draw as we think fit from case law, countries around the world, and from international law. And we're given no assistance as to which, if any, we should prefer or by what criterion. I confess that as a judge trying to interpret the will of Parliament, I would come close to despair. And I certainly find it difficult to see how that's going to curb the judicial activism of which the paper apparently complains, still less promote greater certainty. So that's one proposal, I'm afraid, I hope doesn't get off the ground. The consultation paper also proposes amendments to section 3. Now, you'll recall that provides that, quote, so far as it is possible to do so, primary and subordinate legislation must be read and given effect in a way which is compatible with conventional rights. Now, the paper proposes that the section should be either appealed or amended to limit it to cases of actual ambiguity in the legislation, rather than allowing it to be stretched, as some cases have done. Now, the Gross panel did not think such a change was necessary, and I agree with them. It seems to me that the reasoning behind the consultation paper proposal doesn't really support what is said. What the argument is that, quotes, some of the cases have, quotes, given rise to a significant constitutional shift in the balance between Parliament, the executive, and the judiciary, diverting the courts from their normal function in the interpretation of legislation into straightforward judicial amendment. Now, I don't think the cases they refer to really support that. I will mention one case, which is the case which I was in and is quite recent, called Gillam and the Ministry of Justice. The paper summarized it thus. In 2019, the UK Supreme Court used Section 3 to change the scope of employment rights under the Employment Rights Act 1996 by reading worker much more widely than its natural reading, to include judicial office holders, to avoid incompatibility with Article 14 and with Article 10. Now, I don't, with respect, think that's a very fair reading of the case. The issue was whether a district judge qualified as a worker, quotes, as defined in the Employment Rights Act, so as to be able to take advantage of the protection given to whistleblowers. And if not, whether that involved discrimination against her enjoyment of her right to freedom of expression under Article 14, taken with Article 10. Now, we held that it did involve such a breach, and we also held that it was possible to treat a district judge as a, quote, worker without going against the grain of the legislation. The only difficulty was that the Act referred specifically to contracts, and judges are not employed under contracts. But the spirit was very much the same. And what was important to us was that there was no evidence first that Parliament had given any thought to why judges should be excluded, and no argument was put before us that there was any sensible reason for excluding them. And so we thought that it was perfectly sensible to give effect to that right without doing damage to the legislative position. And in my view, we were, in fact, far from not respecting Parliament's intentions. We were giving effect to the intentions, first, as expressed in the 1996 Act, that workers should have the benefit of whistleblower protection. But secondly, as expressed in the Human Rights Act, that categories of workers should not be discriminated against in the exercise of their convention rights for no reason. Now, if the authors of the paper don't like that result, it'd be interesting to know why. I mean, or what purpose would have been served by requiring the parties to incur the expense and a delay of a trip to Strasbourg to achieve the same result. So I'm afraid I remain unrepentant on that score. Now, there's another problem really with the relationship of the consultation paper and the Gross panel's review, because as you've seen, much of the consultation paper is directed at the Strasbourg Court jurisprudence and the domestic jurisprudence based on it. But the scope of the convention rights as developed by the Strasbourg Court was not within the scope of the Gross terms of reference. So we have no information as to what the Gross panel, which was very expert, would have made of these various complaints. And the challenge for those promoting a new Bill of Rights is not just to point to problems with the existing case law, but to show why matters would be improved by recasting the same rights in a new bill. I mean, again, I'm make no apology for taking a case mentioned in the paper in which I was personally involved. This is a case called Cheshire West. Now, that comes in a section of the paper under the heading Public Policy Priorities and Decision-Making Affecting Public Expenditure has shifted from Parliament to the courts, creating a democratic deficit. And one of the cases discussed is the Cheshire West case, where the Supreme Court decided by a majority that various placements of mentally ill individuals with foster carers or in small homes constituted a deprivation of liberty under Article 5 of the Convention, even though there was no suggestion that the placements were not in their best interest or that they would have wanted to live elsewhere. Now, there's no doubt that that decision did result in fairly dramatic and expensive consequences, of which the court had not been given any adequate forewarning during the proceedings, because deciding that these people who are living perfectly happily in homes or foster care homes were, quotes, deprived of liberty within the convention, mean that they had to be subject to all the deprivation of liberty safeguards, including supervision by the court. And that led to a massive and unanticipated increase in cases having to go to the courts. And it was followed in due course by a law commission inquiry and legislation. Now, I dissented in that case, but it seemed, along with two of my colleagues, because it seemed to us that this was not the natural meaning of the term deprivation of liberty. But my colleagues disagreed. And what the paper doesn't explain is why this position would have been any different under a British Bill of Rights. This, after all, was not an imposition from Strasbourg, but a decision by our own Supreme Court sitting as a seven-justice court. And we weren't applying any Strasbourg jurisprudence. The leading judgment of Lady Hale, which was agreed by Lord Sumption and Lord Newburger, said that a gilded cage is still a cage, and they took the view that that was deprivation of liberty. But this was not an imposition from Strasbourg, but a decision by our own Supreme Court. And the difference between the majority and the minority lay not in any policy disagreement, but in our differing understanding of those simple words, the right not to be deprived of one's liberty. Now, assuming as apparently intended, those rights are reproduced in equivalent language in the new Bill of Rights, it's not clear why the interpretation would be any different. Now, I think the same problem arises in relation to another concern which runs through the paper, which is what's called the incremental expansion of convention rights to include, quote, positive obligations. This is created, as said, uncertainty of the scope of the government's duties, pressuring the way it can make operational decisions determining policy in the wider public interest and allocate finite taxpayer resources. And references made to an example given earlier in the paper, the decision of the Supreme Court in the case of Rabone, in which it was held that the state had breached the positive obligation to protect life under Article 2 in respect to a voluntary psychiatric patient who died by suicide when on medically approved leave from the hospital, and awarded the applicant's damages for the breach. I do have some sympathy with the concern behind that, in the sense that there's no doubt that the rights conferred by the Convention have been interpreted by the Strasbourg Court so as to impose responsibilities which could be said to go well beyond those naturally implicit in the original wording. But the consultation paper does not, as I understand it, suggest that this problem would be solved by its proposed Bill of Rights. It simply asks for ideas. Question 11 asks, how can the Bill of Rights address the imposition and expansion of positive obligations to prevent public service priorities from being impacted by costly human rights litigation? Please provide reasons. So it's over to you, really, to decide what to do about it. And I can understand why they don't have proposals, because it's not at all easy. Positive obligations under Article 2 did not start with the Supreme Court in Rabone. The simple words of Article 2 of the Convention, everyone's right to life shall be protected by law, had been interpreted by previous case law of the Strasbourg Court as imposing on the state not only a negative duty to refrain from taking life, but also positive duties to conduct a proper investigation into deaths for which the state might be responsible, and to take reasonable steps to protect those within its care from the risk of death or suicide, including, for example, psychiatric patients detained in a public hospital. In Rabone, the Supreme Court did no more than hold that the latter operational duty should logically apply to voluntary patients as well as those forcibly detained. So it's not at all clear why the CP thinks that the equivalent right to life in the new bill would be interpreted any differently. The hope may be that a domestic court freed from the need to comply with Strasbourg would develop its own more limited interpretation. But there is no certainty that this would happen, and it could take a long and expensive journey to the Supreme Court to find out. Even then, it would, of course, leave open the prospect of a later adverse ruling in Strasbourg. Now, there is a suggestion in the paper that the answer may lie in legislative guidance. In chapter 3, it is said that the account of the case law demonstrates the ebb and flow of case law between more and less active approaches to judicial legislation on human rights grounds, and reinforces the case for reform so that Parliament can clarify and codify the appropriate tests. Now, if that is the intention, the paper doesn't tell us how these appropriate tests are going to be formulated. And in that context, I suggest that more thought might have been given to evaluating the success or otherwise of past attempts to guide the courts in the application of the Convention. A notable example highlighted by the paper was the Immigration Act 2014, which was designed to guide tribunals as to the weight to be given to the public interest in deportation cases. Now, I welcome that legislation in principle, but I'm afraid I have been quite critical of it in the Supreme Court in a judgment called KO Nigeria in 2018. We had to try and construe the relevant legislation, and we expressed some regret that it had caused such uncertainty among experienced upper tribunal judges and Court of Appeal judges. Indeed, one of the cases had referred to it as an impenetrable jungle. Now, the basic idea is clear enough, but again, I think the consultation paper misrepresents the way it's been applied. There's a passage which criticizes judges for using the discretion given under the Act to, quote, dilute the impact of the act as intended by Parliament. And it's illustrated by two upper tribunal decisions. One is called AD Turkey, where it suggested that the tribunal should not have a Turkish national who was convicted of an offence of grievous bodily harm and sentenced to 54 months imprisonment should not have been protected from deportation on human rights grounds. Now, I'm afraid the summary given by the paper seems to me a travesty of the careful reasoning of the experienced upper tribunal judge who decided that case. There's not time to go into it now, but I certainly suggest that if you want to see how, first of all, how difficult these cases are, but secondly, see a very careful and painstaking attempt to apply the statutory language, have a look at that judgment. I mean, if the authors of the consultation paper thought that the judge had somehow gone wrong in applying the statute, it would be nice to know why. But to my mind, it actually illustrates a very challenging task facing the specialist judges of that tribunal on a daily basis of balancing the public interest and the parliamentary intentions with the realities of the human lives involved. So I come to my conclusion. I'm sorry this has been a slightly hurried presentation, but I think the full text will be available. I found my attempts to grapple with the Gross review and the subsequent CP a frustrating experience. As I've indicated, I have sympathy with some of the concerns expressed in the consultation paper, particularly in relation to the positive duties resulting from the wider interpretation of the Convention. And I'd have welcomed the views of the Gross panel on those issues. And I'd particularly welcome their views on how far those could be addressed by legislative guidance, as is hinted at in the consultation paper. But unfortunately, they weren't asked that question. There's a mismatch between the two exercises. In some ways, they're almost like ships that pass in the night. It's a pity that the problems which came up in the consultation paper were not there at the outset. The reason, as far as I can judge, is that there was a change of leadership in the department in the meantime. As I think I've indicated, my own experience of the convention as advocate and judge has been generally positive. On the whole, I regard it as a success story. I find it a matter of pride that what was originally a British-led project initiated at a time when the recognition of any sort of human rights across much of Europe was at best a distant dream. That system is now embedded in the law of 47 countries, supervised by a central court in which all participate. Now, one of my colleagues has described the spreading human rights, the aspiration of spreading human rights in this way as a, quote, noble but unrealistic ambition. And of course, as he says, the historical experience of the 47 countries is extremely varied, but that is no reason for not allowing the basic rights to be recognized by the Convention as common to all. Of course, there are problems of putting that ideal into practice, but that is no reason for abandoning the project. On the contrary, we should be proud as a country of the part we have played and do everything in our power to take it forward. Now, as I've already mentioned, the UK has not only initiated the Convention project, but has also been at the forefront in recent years of attempts to improve it through the Brighton Declaration and Protocol 15, which I mentioned. Now, those developments are indeed noted by the consultation paper, and it's said with some pride that they were inspired and negotiated under UK stewardship, and quotes, they create space for state parties to assert the margin of appreciation over matters which, particularly in a mature liberal democracy, should be left to national courts and elected legislators, and they provide an opportunity to avail ourselves of this commitment to an increased margin of appreciation and to make sure it is properly adhered to in the future. Now, that's fine, and I agree with it, but the challenge is how to take this forward. Now, that needs to be done by jointly with the UK courts and tribunals who have most experience of operating the convention in practice, and in cooperation with our political and judicial colleagues in Europe. Now, but I'm afraid at the moment the consultation paper doesn't really provide the answer, and I'm certainly wholly unpersuaded that the establishment of a new UK Bill of Rights to be administered by the UK courts, but parallel to the still binding convention administered by the Strasbourg Court, is going to assist the process. So thank you very much for your attention.
Thank you very much, Lord Carnwath, for that very fascinating and interesting lecture. And thank you in particular for your heroic efforts to overcome many technical difficulties and challenges and still deliver a really interesting and stimulating lecture. We have had some questions that have come in from the audience, and I would also encourage people to send in further questions through the Q&A section. And if not, I will be forced to ask Lord Carnwath questions. I'm sure he'd prefer to have questions from the audience. I think he's well used to my questions and my views on some of these issues. But the first question I'd like to put to you, if I may.
There seem to be 3 questions already, actually.
There are. I'm going to put them to you, if that's okay. Are you ready?
Yes,
are you ready for them?
I'm going to have to leave by 1:45, I'm afraid. So
that's absolutely fine. Thank you so much for the time you have been able to give us. So the first question I have is with regard to section 2, and it's asking whether you can anticipate a radical change in approach from the UK courts, given that under the proposed section, obviously the UK courts would still be able to have regard to Strasbourg. So the questioner is wondering whether this is really just an optic change rather than a radical legal change.
I don't know the answer, I'm afraid. I'm quite glad that I'm not going to be faced with having to do it, because I mean, if it's just an optic change, well, there's obviously no point in doing it. I mean, it's clearly intended, I think, to sort of suggest we should look elsewhere. But again, I don't see why it's thought that elsewhere will provide anything more acceptable to the authors than what Europe is doing. I'm afraid I can't really say more than that.
No, I think I share your concerns. It's very difficult to know precisely what difference it will make in practice, and we still will have to be bound by decisions addressed to the UK as a state anyway. So I'm glad I don't have to apply either. I think it's going to be very interesting to see where it goes. A second question we've had with regard to human rights is asking you what you think the best way might be to solve fears of human rights mission creep. So this idea that somehow human rights are exploding beyond original intentions.
Yes. I think one's got to be specific. I think this is the trouble. One of the things I find difficult about the consultation paper was it sort of has a sort of discussion of quite a lot of cases, but it's not at all clear to what extent they're regarded as really objectionable. I think that one needs targeted, I'm sure there are ways which one could, by legislation or administrative measures, provide guidance which the courts will then take account of. I mean, I think you're absolutely right to emphasize the margin of appreciation. And I'm quite sure that that's going to be reflected in the approach to the Strasbourg Court and our own courts, that if the government is able to show that these issues have been considered and that the proper proportional approach is taken, then the courts will respect that. So, I think one's got to be very much more targeted than just all throw up one's hand and say mission creep is a general problem.
I think that's right. I think we've had another question which builds on your point to do with the margin of appreciation, and it asks whether so to what extent would the European Court of Human Rights, applying a broader margin of appreciation in general, meet the government's objections, And would this be desirable?
I think it will. I mean, one of the troubles is there's so few cases actually go from this country to Strasbourg. I mean, it's minuscule. I think if you look at there's quite a lot which actually try, but most of them are struck out. And I think in the last year there was about sort of 4 cases decided, of which 2 were violations. So really, it's not a serious problem, frankly. And one of the reasons for that is that we are dealing with the cases here. But having said that, I think what is very interesting in the St. Peter's panel's review is the discussion of Europe, the relationship with Europe, and how that has actually developed very strongly in recent years. And there's a really useful dialogue. Would you let me just have a quick? There's someone's attacking my judgment in privacy. No,
I saw that. I didn't know if you'd be wanting to answer that or not.
Well,
but if you're willing to reply, please do.
Well, I mean, the answer is got nothing to do with the present subject, but I would ask people to read, if they're at all concerned about that, to read my judgment, which was intended to be in Privacy International, was intended to be a faithful interpretation of the law as stated 50 years before in the case of Annis Minnick, but this is probably not the place to be.
I have to admit that the idea that you suggested that even if an ouster clause is clearly you can decline to apply it is an exaggeration of your judgment. I think it's fair to say.
So we take it up with him.
I suggest they read your judgment, I think, and then they'll understand the difference between the statements.
It is quite long. It is quite long, I'm afraid. I'm sorry.
It's only 131 pages. And we have another question with regard to human rights. And this is looking at the idea that given that the Scottish government is proposing a new human rights bill, is there a risk of there being different rights across the United Kingdom?
I'm sorry, I haven't really been keeping up with the proposals in Scotland for a human rights bill. So I'm ashamed to say I'm not really in a position to answer that. I mean, Alison, you may know more than I do about that.
I haven't seen the proposed human rights bill, but I think there are issues where there might be possibilities of divergence, and I know the consultation paper has asked questions about the consequences for devolution and how far that will go. But obviously, the big problem would be how far you can incorporate it. So that the clarification was the UN treaties. So this is referring back to the recent reference in the UNCRC case, where it was interpreted that Scotland wasn't allowed to bring in that particular incorporation of UN treaties because it would have an impact on Westminster's ability to enact law for Scotland. And I think that might restrict the extent to which there can be divergence, which we do have at the moment, because obviously Wales has already incorporated the UNCRC in Wales. So that
I think there's scope for additional rights to be incorporated. I mean, I think, but I don't think that would really affect the sort of issues of whether we should keep the European Convention as our basic framework of rights.
No, I think you're right. I mean, it is going to be interesting. Another area where there might be possible divergence is with regard to the right to jury trial, because obviously that is interpreted differently in Scotland, and obviously there are differences with regard to Northern Ireland as well. So, yeah, it'd be interesting to see how far divergence might arise from this.
I see someone asked if the paper is going to be shared. I mean, what's the normal form? Would you? I mean,
well, we'd be, if you're happy to share your paper, we would be happy to publish it through the website, and then we can publicize that and send everyone a link. So we'd be very, very grateful if you're willing to do so.
Yeah. Good. Well, thank you. I think I'm going to have to go in a second. My wife, having lent me her computer, is pressing the door for us to go out. Is there anything else I can deal with then while I'm
No, I think we've dealt with all of the questions. So it just remains for me, on behalf of everybody, to thank you for what was for me a fascinating lecture, and a really excellent insight into the reality of what it's like as a judge to be dealing with these issues of human rights, drawing on your experience of judging in these important cases, but also I think drawing attention to the importance of legal clarity, and also the divergence between the Gross report and the consultation paper. So I found it absolutely fascinating, and it just remains for me to thank you tremendously for agreeing to give this lecture. And I think everybody, on behalf of I can say on behalf of the faculty, not just only thank you, but we're really looking forward to working with you as a distinguished visiting fellow at the university, and also to thank everybody who helped organise the event, and to thank our audience for listening. So thank you very much, everybody, for attending.
Thank you.
Good evening.